Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in Morgan v. Sundance, certiorari to United States Court of Appeals for the 8th Circuit, argued March 21st, 2022, and decided May 23rd, 2022. Petitioner Robin Morgan worked as an hourly employee at Taco Bell franchise owned by respondent Sundance. When applying for the job, Morgan signed an agreement to arbitrate any employment dispute. Despite that agreement, Morgan filed a nationwide collective action asserting that Sundance had violated federal law regarding overtime payment. Sundance initially defended against the lawsuit as if no arbitration agreement existed, filing a motion to dismiss, which the district court denied, and engaging in mediation, which was unsuccessful. Then, nearly 8 months after Morgan filed the lawsuit, Sundance moved to stay the litigation and compel arbitration under the Federal Arbitration Act. Morgan opposed, arguing that Sundance had waived its right to arbitrate by litigating for so long. The courts below applied 8th Circuit precedent, under which a party waives its right to arbitration if it knew of the right, acted inconsistently with that right, and prejudiced the other party by its inconsistent actions. That's Erdman versus Phoenix Land and Acquisition. The prejudice requirement is not a feature of federal waiver law generally. The 8th Circuit adopted that requirement because of the federal policy favoring arbitration. Other courts have rejected such a requirement. This court granted certiorari to resolve the split over whether federal courts may adopt an arbitration-specific waiver rule demanding a showing of prejudice. The Supreme Court holds. A decision below is vacated and remanded, and Justice Kagan delivered the opinion for a unanimous court. The 8th Circuit erred in conditioning a waiver of the right to arbitrate on a showing of prejudice. Federal courts have generally resolved cases like this one as a matter of federal law, using the terminology of waiver. The parties dispute whether that framework is correct. Assuming without deciding that it is, federal courts may not create arbitration-specific variants of federal procedural rules, like those concerning waiver, based on the FAA's policy favoring arbitration. That's Moses H. Cone Memorial Hospital versus Mercury Construction Corporation. That policy is merely an acknowledgement of the FAA's commitment to overrule the judiciary's long-standing refusal to enforce agreements to arbitrate and to place such agreements upon the same footing as other contracts. Granite Rock versus Teamsters. Accordingly, a court must hold a party to its arbitration contract just as the court would to any other kind. But a court may not devise novel rules to favor arbitration over litigation. See Dean Whittier Reynolds versus Byrd. The federal policy is about treating arbitration contracts like all others, not about fostering arbitration. The text of the FAA makes clear that courts are not to create arbitration-specific procedural rules like the one here. Section 6 of the FAA provides that any application under the statute, including an application to stay litigation or compel arbitration, shall be made and heard in the manner provided by law for the making and hearing of motions, unless the statute says otherwise. A directive to treat arbitration applications in the manner provided by law for all other motions is simply a command to apply the usual federal procedural rules, including any rules relating to a motion's timeliness. Because the usual federal rule of waiver does not include a prejudice requirement, Section 6 instructs that prejudice is not a condition of finding that a party waived its right to stay litigation or compel arbitration under the FAA. Stripped of its prejudice requirement, the 8th Circuit's current waiver inquiry would focus on Sundance's conduct. Did Sundance knowingly relinquish the right to arbitrate by acting inconsistently with that right? On remand, the Court of Appeals may resolve that question, or determine that a different procedural framework, such as forfeiture, is appropriate. The court's sole holding today is that it may not make up a new procedural rule based on the FAA's policy favoring arbitration. The decision below is vacated and remanded. Justice Kagan delivered the opinion for a unanimous court. If you'd like to support me, find the PayPal link in the show notes or get a hold of me at rhodesscholar80@gmail.com. That's ROADS and the number 80.